Okay, I want to welcome everyone and thank you for joining us today. This is Museum Studies' fourth webinar this year. It's the law, an introduction to legal issues for collecting objects. I'm Brad Bredehoff with Museum Study. We provide online professional development for people who work in or with cultural institutions. I see a few familiar people here who have taken our courses or attended our past webinars. In fact, several of you were at the one John did 2 weeks ago. John is a museum consultant, author, editor, and curator. You may know him as the author of Things Great and Small, Collections Management Policy. He has authored more than 150 popular and technical articles and books on museum studies and natural history topics, including Museum Registration Methods, Volume 6, with Tony Kaiser. John leads our 4-week-long online course, Laws and Collections Management, that will run in August this year, which I see a couple people have already signed up for. John also leads our Policies for Managing Collections course, which is what the webinar he gave 2 weeks ago was about, and that will run in July, beginning July 3rd. We're excited to have such a large group again. More than 100 people registered for this webinar today. So excited to see the level of enthusiasm, definitely more than we were expecting on this topic. This webinar is being recorded and will be available on our YouTube channel. I will send a link to the recording for everyone who registered for this, so you'll all get it. I will also resend the attachment of the resources that John provided for this one, in case any of you didn't get it when I sent out the link to the Zoom. I will also drop it in the chat later. Please mute yourself during the presentation, but once the presentation is over, we're going to have Q&A. At that time, feel free to unmute yourself if you would like to ask your question. Alternatively, you can also ask questions using the chat box. You can ask them during his presentation. So if something occurs to you while he's talking and you want to get it out while you're thinking about it, feel free to drop it in the chat and I'll make sure that he gets to it when we get to Q&A. Or you can wait until after his presentation is over. With that said, I will turn it over to you, John.
All right. Can you see the screen all right?
Yes.
Okay, very good. So thank you for this opportunity to talk to you today about laws and regulations that affect how we acquire objects, artifacts, and specimens for our collections. The maze of laws and regulations that govern collections can be really difficult to navigate, but it is important for us as museums, as public institutions, to do our best to comply with all of the legal standards. So I'll start with a few caveats. First, and most important, I am not a lawyer. And in fact, I have no formal training in the law at all. My academic degrees are in biology and in museum studies. So the point of view that I will present today is that of somebody who has spent more than 50 years collecting objects, artifacts, and specimens, and managing collections, dealing with the legal issues associated with them, and sometimes even talking to lawyers. So keep in mind that if you or your museum needs legal advice, get it from a lawyer. Legal issues can get very complicated, and it's not one of those things you should try and take on by yourself. And remember that what I always have to remind myself of, even lawyers hire other lawyers when they have legal problems. So that tells you how complicated that it can be. So let's start with a little bit of history and some definitions. A general definition of the law is that it is a system of rules and guidelines for human behavior that are created and enforced by social or government institutions. So laws, as far as we know, are as old as human societies. For example, the pillar that's in this image contains the text of the Code of Hammurabi, which is a legal document from Babylon that was composed nearly 4,000 years ago, and it was very complex. The Code of Hammurabi is the longest, best organized, and best preserved legal text in the ancient Near East, and it did pretty well what our laws and regulations do today. It established principles of fairness before the law and respect for the rule of law in a very complex society. It's important to distinguish between laws and regulations. A law is a rule of conduct or action prescribed or formally recognized as binding or enforced by a controlling authority. A regulation is an authoritative rule or order issued by a government or agency, and a regulation may or may not have the force of law. And so we run into regulations internationally far more than we do laws. So legal systems vary widely around the world, and even within a particular country, the laws may vary greatly from one jurisdiction to another. And by jurisdiction, I mean the area under control of a specific government entity, such as a nation, a state, or a city. And so those of you that live in the United States know that laws vary from state to state, and sometimes within a state, they vary from city to city. And so here's an example. This image shows part of the inscription of the Gortine Code, or the Great Code of Civil Law, from the 5th century Greek city in southern Crete of Gortine. And it was a laws for that particular city-state. So it's also important to understand the way legal systems have evolved in different places, because this is what gives laws differences. Common law comes from the English-style governmental system that is found in the United Kingdom, the United States, Canada, and many other countries, particularly countries that are former English colonies. Common law is based on what's called precedent and the principle of stare decisis, which is a Latin phrase that means to stand by things that are subtle. So when enforcing laws, we look back to the way laws were enforced in the past. So this means common law systems use legal precedents to ensure consistency and stability in the way law is administrated. Civil law is also called continental law. This is a European system. It's found throughout Europe and also in many other countries, and particularly countries that used to be European colonies rather than English. And it's often found in conjunction with civil law, which is the case here in the United States. The primary source of civil law is an organized system of rules or principles. And civil law goes back to the 6th century and the Code of Justinian that was developed by the Romans. The Code of Justinian refers to a general statement of legal principles that were used to interpret law. So here in the United States, we actually have both. We have civil law, but we also have common law working with the civil law system. So it gets rather complicated. To show you how complicated, this is a worldwide map of legal systems. For instance, the legal systems of most countries in Latin America are based on civil law. Most African countries use a legal system called legal pluralism, because this has the European colonial powers imposing either common law or civil law on top of an indigenous legal system that had already been in place for thousands of years. And as you can see from the map, things get even more complicated in some Asian countries, in the Middle East, and in Oceania. So we aren't going to go into all these details today. It's sufficient to remember that the system of law that you are in is going to vary from one place to another. So we need to keep that in mind. We often think of the concept of international law as something that is very modern, but in fact, it goes back to antiquity. One of the earliest recorded examples of international law is a peace treaty between the Mesopotamian states of Lagash and Umma that was negotiated in 3100 BCE. So it's been around for quite a while. International law is made possible only by the voluntary consent of the countries involved. And this is because we have no universally accepted authority to enforce international law on sovereign states. And if you follow what happens with international laws, you'll see from time to time there will be a rogue state that refuses to comply. International law is basically a set of agreements, treaties, legislation, and rules that are agreed to by a group of nations to provide guidelines for such things, typically as diplomacy, economic relations, war, human rights, and cultural property. And it's this last category, cultural property, that is important for museum collections. And that's the one we'll focus on when we talk about international law in a little bit. Then this brings us around to museum law, which in fact is not a formal category of law at all, even though there are lawyers who specialize in museum law. Museum law is a very general term for all of the laws that affect museums, and there are a lot of these. They affect the governance, they affect personnel, finance, collections, import and export of cultural property and scientific specimens, contracts, sales, insurance, public safety, a lot of other concerns. And for museums located within the United States, there's another set of laws that affect nonprofit organizations that are also in place. So all of this is what goes into museum law. In the class that I teach for museum study called Laws and Collection Management, we go into a little more detail about some other aspects of museum law. But due to time limitations for this webinar, we're going to focus on the most significant laws and regulations that apply to collecting for art, history, and natural history collections. But keep in mind, there is a lot more to museum law than just the laws that regulate collecting. The textbook we use in that class is a legal primer on managing museum collections by Marie Malaro and Ilde De Angelis. And this is a standard reference that I think every collection manager and registrar should have at their desk. It's an extremely useful book. In working with museum collections, the laws and regulations that we are usually concerned with are those that affect the acquisition, export, import, and international trade in objects and specimens. So that's what we're going to focus on today. So a critical issue for collecting institutions is taking ownership of what we collect. So our specimens, artifacts, and objects for things we want in our collection. This process can be divided into 3 steps: acquisition, assuming ownership, and then accessioning the objects into the collection. Most people treat the words acquisition and accession as synonyms, but that is incorrect. They're really not. Acquisition means simply acquiring an object, but it doesn't necessarily mean that you take ownership of it. Accessioning means making an object formally part of a museum's permanent collection. And that is why we always say you should never accession an object you don't plan to keep. You should only accession things that you plan to keep in the collection for a very long time. Ownership, however, means making the object yours. Legally, taking ownership is often referred to as transfer of title, but this can be confusing because title means different things for different objects. Title to an object really means the proof of ownership. So that might be an invoice or a receipt, a bill of sale. It may be an official document that conveys the right to collect or export that object. If we're talking about collections of archaeology or natural history, proof of ownership is usually not that at all. It is usually the legal documents that allow you to possess those artifacts and specimens, and if they're out of the country, to export them. So proof of ownership can be a lot of different things. And accessioning is the place where 2 Latin phrases that describe legal principles become very important: caveat emptor and nemo dat. Both of these are abbreviations for longer phrases. So here's what they mean. Most of us are familiar with the disclaimer caveat emptor, which means buyer beware. The full phrase in Latin actually means let the buyer beware, because he should not be ignorant of the nature of the property he is buying. So as a legal doctrine, this means the burden is placed on the purchaser to make a reasonable, good faith effort to examine the property they're purchasing. So if they don't look at the property closely and they buy it, they then find out there's something wrong with it, that's too bad. They're stuck with it. The doctrine of and nemo dat is a short way of saying no one can give what they do not have. This means the seller of an object cannot transfer the title to the buyer if the seller does not own the title, if the seller does not have that title. In short, this means if you buy a stolen object, no matter how good faith what good faith you purchased it in, thinking it was legitimate, you still don't get the title for it. And in fact, you will have to return it to the rightful owner. So not only will you have to give up the object, you will also probably have to give up the money you spent to buy it in the first place, because the person that you bought it from probably isn't going to give you your money back. So those 2 phrases are really important. It means when you want to purchase or acquire, take ownership of something, you want to make sure that you legally can do that and that it will be yours. So this is why provenance, the history of ownership of objects, is really important in the museum world. So I want to give you an example of how things can go very wrong when you're acquiring and accessioning objects in a collection if you don't do good provenance. When the Museum of the Bible in Washington, D.C. was founded in 2010, it was founded as a nonprofit organization by the Green family who own Hobby Lobby. They spent an enormous amount of money acquiring objects for exhibition and research. Despite the fact that they hired internationally known experts as their curators, they failed to do adequate provenance research on many of the things that they purchased. So as a result, in 2017, Hobby Lobby, which is owned by the Green family, was fined $3 million by the U.S. government for failing to declare antiquities that were imported into the United States. They had them shipped in as if they were just merchandise. And then the museum had to send back 5,500 objects they had purchased from European dealers back to Iraq because the objects had been obtained illegally and the dealers shouldn't have been selling them. In 2020, the museum learned that all 16 fragments of the Dead Sea Scrolls that they had paid millions of dollars for, in fact, were forgeries. And in 2021, the museum had to send back 5,000 stolen objects to Egypt and more than 8,000 stolen objects to Iraq. In 2022, the museum had to return a handwritten manuscript to a Greek Orthodox monastery. So after all this, the founder of the museum, Steve Green, has been quoted as saying, "I trusted the wrong people to guide me," and that he unwittingly dealt with unscrupulous dealers. He now says that in the future, the museum will only acquire objects with reliable, documented provenance, which is, of course, what they should have done in the first place. And the only way that the Green Foundation will ever recover the money they spent on those objects is by trying to sue the dealers who sold them the objects in the first place. So this can get very messy if you don't do good provenance research. In the laws and collection management class, we discussed some of the court cases that result from violations of laws and regulations. We don't have time to go into that kind of thing today, but looking at the court cases is a good way to get an understanding of how laws and regulations are enforced and what the consequences are if they are violated. But what we'll do today instead is first review the most significant laws of the United States that affect collecting. And this is because I do not have the time or the expertise to talk about laws that are specific to other countries. However, the laws of the United States are fairly representative of what you will find in most other countries regarding acquisition of objects. And after we do that, we will then consider the most significant international laws, treaties, and regulations that affect the exchange or acquisition of objects, artifacts, and specimens by museums. So we'll start with U.S. laws, beginning with the Antiquities Act of 1906, which protects historic structures on public lands from being destroyed or damaged. This law was passed in response to vandalism that was taking place at the ancient Native American city of Casa Grande in Arizona, and also because there were concerns about protection of Mount Vernon in Virginia. Mount Vernon is the home, of course, of the first U.S. president, George Washington. So the act authorizes the President of the United States to declare by public proclamation historic landmarks, historic and prehistoric structures, other objects of historic or scientific interest that are situated upon lands owned or controlled by the government of the United States to be national monuments. So the president can declare something to be a national monument. It's important to note the president cannot make a national park this way, only a national monument. The act then goes on to mandate that you have to have permits to gather or excavate objects of antiquity from federally controlled lands. One thing the Antiquities Act does not say is whether a president can remove status of a national monument. And this is interesting because this is an ongoing case right now. In 2016, then President Barack Obama established the Bears Ears National Monument in Utah, using his authority as president under the Antiquities Act. And he noted that the area has extraordinary archaeological and cultural record, and that it was profoundly sacred to many Native American tribes. 11 months later, the next president, which was Donald Trump, reduced the size of the monument by 85%, primarily due to a request from a company that wanted to mine uranium in the area. And then in October 2021, the current president, Joe Biden, issued a proclamation to restore the monument to the size that Obama had established. And the next thing that happened was the state of Utah filed a lawsuit claiming that President Obama's declaration restoring the monument was not legal. So this is a very interesting case. It's going to be in the courts for some time, and it's one to watch because this is one of those things that tells you how the laws get interpreted and how they get enforced. And it's a good example of how complicated a seemingly straightforward legal issue can be. The Historic Sites Act of 1935 strengthened the Antiquities Act, and it did this by making it a national policy to preserve for public use historic sites, buildings, and objects of national significance for the inspiration and benefit of the people of the United States. The Historic Sites Act also expanded the historic preservation role of the National Park Service, and it enabled the protection of historic sites such as the Hopewell Iron Furnace near Philadelphia, which is shown here. And this was an important site because it's the early industrialization taking place in the United States. The Archaeological Resources Protection Act of 1979 expanded the Antiquities Act again. So this is an important thing to note, how the laws can be linked to one another, going back, in this case, back to the original law in 1906. And it's strengthened at this time by protecting archaeological resources and sites on public land and Indian land, and by regulating access and prohibiting the sale, purchase, transport, exchange, or receipt of archaeological resources that were removed without permission. And it's interesting to note here that archaeological resources were defined as any material remains of past human life or activities which are of archaeological interest and were at least 100 years old. And this includes paleontological specimens if they are found within an archaeological context. And an example of this is the fossils that can be found on Pine Ridge Indian Reservation in South Dakota. Those are protected under the Archaeological Resources Act. So in this photo, my friend Sally Shelton is leading a tour of the museum collections at the South Dakota School of Mines, where they have fossil specimens from Pine Ridge. And what you do not see in the photo are those fossils, because the fossils are kept separate from the rest of the collection at the request of the tribal elders from Pine Ridge, and they can only be seen with permission of the tribe. So the museum keeps them, but checks with tribal elders before they are allowed to be photographed or used, because they belong to the tribe. The Pre-Columbian Art Act, which the full name is Pre-Columbian Monumental or Archaeological Sculpture or Mural Act, prohibits the importation of pre-Columbian artifacts or pre-Columbian objects of art, stone carvings, wall murals, frescoes, mosaics, graffiti, and other decorations without a certificate of export from the country of origin. And this was passed in 1972 because at that time, the market for pre-Columbian art had increased greatly. It had become very collectible, and a lot of things were being looted in the Americas, particularly Central America and South America, and brought into the United States. So this law was designed to prevent that. The immunity from seizure under judicial process of cultural objects imported for temporary exposition or display protects foreign-owned works of art or objects of cultural significance that might have questionable provenance from being seized by a U.S. court when they are brought into the United States for temporary exhibition. So this means a traveling exhibit that had a few objects where it really wasn't clear whether they were legal or not. It was a little murky. If that someone wants to tour that exhibit, you can apply in advance to have those objects protected while they're in the United States. So it would prevent a U.S. court from seizing them. But to do that, the museum has to apply for protection in advance before the objects are brought in. And if the court does not agree with you that those objects should be protected, then they could seize them. So that's important. The objects that are eligible for protection from seizure under this act include works of art, artifacts, rare documents, books, and other printed materials, photographs, films, and videotapes. So this is a way when you have objects that are really, truly, you don't know if they're legal or not, to give them some protection while they're touring around the US. That will not work for importing them permanently, of course. A very important piece of legislation for museums is the Native American Graves Protection and Repatriation Act, or NAGPRA, which became law in 1990. In short, NAGPRA affirms the rights of Native Americans, Native Hawaiians, and Alaska Natives to claim custody of human remains, funerary objects, sacred objects, and objects of cultural patrimony that are the heritage of their cultural group. NAGPRA requires that museums that receive federal money, and that includes grant money, and all federal agencies have to compile an inventory of Native American collections and human remains that are under their control, and then work with the appropriate tribe or cultural group on whether the objects should be repatriated, or in some cases, how they should be cared for if they are kept in the collection. So NAGPRA covers new acquisitions as well as past acquisitions, so all incoming collections have to conform to NAGPRA. And although NAGPRA is a US law, many other countries are instituting similar legislation using NAGPRA as an example. I was recently in Peru, and Peru is working on a law similar to NAGPRA, and they are taking the NAGPRA law and using that as a guideline. And so because it's being used internationally, I thought we should spend a little bit of time looking closer at this law in the history of its interpretation and application, because that has actually changed over time. The way the laws are interpreted will sometimes change based on court rulings or enforcement experience, and sometimes formal updates in the laws. In the case of NAGPRA, the United States Department of the Interior, which is responsible for enforcing it, has announced several proposed changes and interpretation and enforcement for 2023. And this is after consulting with 71 cultural organizations and tribes. The changes are designed to streamline the process of compliance and repatriation in order to make the law work better. One of the biggest changes is that objects that cannot be demonstrated to be the heritage of an existing cultural group, which is what the law originally said, can now be claimed based on their geographic origin rather than proof of ownership. So if your tribe or cultural group lived in a particular area, whether that object can be demonstrated to be culturally related to your group or not, if it's within the geographic area where your tribe or culture lived, you can make a claim to it. Another proposed change is that the classification of objects as sacred or cultural patrimony will now be based on the current beliefs stated by the tribe or cultural group, rather than on beliefs of the past that are part of the group's cultural heritage. There are some changes that make what are deemed federal lands and Hawaiian lands different, and this means objects that are now in museum collections that have not previously been subject to NAGPRA may be, particularly when private lands become federal lands, as well as objects that are on land that is leased by the federal government but not owned by the federal government. The rules against the exportation of Native American cultural objects will be strengthened by what is called the Safeguard Tribal Objects of Patrimony, or STOP Act, which became law in December 2022. The STOP Act requires that Native American cultural objects intended for export must first be reviewed by federally organized tribes, Hawaiian organizations, or Alaska organizations, and only exported if they grant a permit. This act was made because there were a number of controversial exports of Native American objects that were sold privately and then exported out of the United States. And this will allow the tribes to get a chance to claim ownership of those objects before they're exported. And in addition, NAGPRA will now have a new purpose statement, and it says that museums and federal agencies must defer to the customs, traditions, and Native American traditional knowledge of lineal descendants, Indian tribes, and Native Hawaiian organizations, rather than other sources of information, such as the anthropological literature, when determining what is affiliated with a particular group. So this is an example of how more than 20 years after it was founded, after it was in place, I guess actually 30 years, the interpretation and the way the law is enforced has changed. And so this can happen with any of the laws. The definitions of funerary objects, sacred objects, or object of cultural patrimony were previously based on proof of lineal descent. They will now be based on Native American traditional knowledge rather than scientific or historic evidence. And there are some changes to the duty of care that's expected of museums and institutions that will impose restrictions on how objects are handled using traditional practices defined, again, by the tribe based on their practices today. So there's quite a number of changes. The Lacey Act of 1900. This is one of several pieces of legislation that you might think affects only natural history collections, but in fact, it affects all collections. So it was enacted to control the trade in bird feathers. At the time of 1900, bird collectors were devastating bird populations to collect feathers to use mainly for ladies' hats. So the Lacey Act was subsequently extended to cover almost all animal and plant species. What the act does is it prohibits the import, export, transport, sale, receipt, acquisition, or purchase of any animal or plant that was obtained or transported in violation of any other law or regulation. So in effect, the Lacey Act enforces the laws and regulations of other countries as well as the US by preventing the importation of illegally collected specimens of plants or animals. Under the Lacey Act, any recipient of an illegal plant or animal specimen may be held responsible and charged with a violation of the act. So it's not just the collectors of the specimens that are affected, but it could be the people who receive those in museums. The Lacey Act includes any object or artifact that contains any part of an illegal animal or plant, including artworks, historical objects, or ethnographic objects. And so this is important. The act defines specimen as any part of that animal or plant. And so for this reason, it's really important to know about the laws that affect natural history objects, even if you don't work with natural history objects. Here are some examples of objects in art and history museums that are subject to the Lacey Act. On the left is a carving made from elephant ivory, now at the Getty Museum. In the center is a blanket decorated with tropical bird feathers that's now in the National Museum of the American Indian in Washington. And on the right are some bones and a human skull that are part of an art installation called The Death of St. John that was done by Damien Hirst that's now at the Minneapolis Institute of the Arts. All of these objects are covered by the Lacey Act. CITES is an example of an international law that the United States is a signatory to and therefore enforces. And CITES is short for Convention on International Trade in Endangered Species of Wild Flora and Fauna. It was established in 1973, went into effect in 75. Its purpose is to protect species that are threatened by international commercial trade, and they do this by regulating and monitoring import and export. Protected species are listed in one of three appendices, depending on the level of protection. Compliance with CITES means that if you are moving a listed specimen, so any part of a protected animal or plant, across an international border or between domestic institutions, you need a special permit, and this includes loans of anything that would contain, for example, ivory or pieces of teeth, or bone, or feathers, or anything like that. So in other words, CITES covers not just natural history specimens, but anything that includes animal or plant species. People sometimes confuse CITES with the Endangered Species Act because both of these publish a list of protected species. But CITES is an international agreement. The Endangered Species Act is US law. Some species occur on both of the lists, but the two lists are not identical. This is because CITES lists only plants and animals that are affected by international trade. The Endangered Species Act lists species that are threatened or endangered for any reason, including loss of habitat. And there's some other wildlife laws we're not going to talk about today that are important to know too. And if you're working with objects that contain plant and animal parts, remember these. These include the Migratory Bird Act, the Bald and Golden Eagle Protection Act, the Marine Mammal Protection Act, and the African Elephant Conservation Act. And most of these are effective because they're either working with feathers or ivory, which are very commonly found in historic objects, ethnographic objects, and often in art objects as well. So at this point, we're going to change over to look at some international laws and regulations. As we go through these, you'll notice that in some cases, the United States has been very tardy in ratifying the agreements. So in other cases, it has not yet ratified them at all. This has been a cause for concern for a lot of museum professionals who recognize the importance of international laws and regulations to protect cultural patrimony. The situation is getting better. In a 2006 article in AAM's Museum magazine about international laws and cultural objects, it said that the law of this country, meaning the United States, has steadily evolved in the direction of enforcing foreign claims regarding antiquities and other objects protected by cultural property laws. A healthy respect for the breadth of foreign law, coupled with an eye for spotting gaps in the provenance of antiquities under consideration for acquisition, can provide important protection against future legal claims. And I think it's really important to remember that provenance is the key. You should do your homework, check the ownership history of an object before you acquire it. So the first international convention that affected museums was the Hague Convention of 1954. This is the Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict. And this was enacted. It was the first significant international agreement to protect cultural property from looting and export during wartime. And this was a reaction to the destruction of cultural property that took place during World War II. The definition of what is covered is very broad. The convention states that damage to cultural property belonging to any people whatsoever means damage to the cultural heritage of all mankind. So it pretty well affects everything. Cultural property is defined as movable or immovable property. So it's everything from structures to works of art to artifacts. And looting has unfortunately always taken place during armed conflict and continues today. Most recently, we see objects showing up in the market that were looted from Iraq, Afghanistan, Syria, and of course now the Ukraine. The Hague Convention Second Protocol was added to the Hague Convention in 1999 to provide guidelines for invoking what were called military necessity waivers, so exemptions to the Act, and also to clarify when enhanced protection might be granted for particular property. These guidelines are overseen by a 12-member international committee. At present, 133 countries are parties to the Hague Convention, but only 83 have ratified that second protocol. The United States did not get around to ratifying the Hague Convention until 2009, which was very late, and we have not yet ratified the second protocol. The international agreement called the Convention on the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property, which fortunately goes by the shorter name of the UNESCO Convention, was ratified by the United States in 1972, but it didn't become effective for 11 years because it wasn't until 1983 that Congress got around to passing the Cultural Property Implementation Act to make this effective. The UNESCO Convention makes certain forms of cultural property subject to seizure if they are imported and authorizes the President of the United States to enter into bilateral agreements with other countries to prohibit the importation of certain cultural property. So in contrast to the Hague Convention, the UNESCO Convention is focused on peacetime destruction and looting of cultural property, particularly things obtained without permission from the country of origin and later sold and imported into other countries. So far, 140 countries have ratified the UNESCO Convention. The UNESCO Recommendations for the Protection of Movable Cultural Property supports an international exchange in cultural property, but at the same time, it urges museums to reinforce measures to reduce risks to movable property by implementing comprehensive security measures and by providing proper environmental conditions for the exhibition and storage of cultural property, and by doing regular collection inventories to make sure things have not been stolen from your collection. The International Institute for the Unification of Private Law, which is called UNIDROIT, has a convention called the International Return of Stolen or Illegally Exported Cultural Objects, and it's usually just called the UNIDROIT Convention. This was written to correct some loopholes in the 1970 UNESCO Convention, and it does this by making it easier to identify the current location of stolen property and making it easier to recover it. The UNIDROIT Convention provides a means for a government to recover stolen or illegally exported property, and that includes objects which were illegally excavated. Although the United States participated in the writing of the convention, the U.S. government has still not ratified it, but it has been ratified by 58 other countries. This law is very important to stop illegal international trade in cultural property. And an example of the objects in this photograph. So I took this picture in the Dominican Republic. These are objects that were illegally excavated and exported from Peru. They were confiscated in the Dominican Republic on their way to a buyer in the United States. So this shows you how complicated these routes of transport can be, why international agreements are necessary, and particularly why the UNIDROIT Convention should be ratified, because that gives Peru a lot more tools to use to get back its property. The UNESCO Convention on the Protection of Underwater Cultural Heritage has not yet been ratified by the United States either. This is a fairly new convention, and it is written because the traditional admiralty laws and salvage laws allow almost anyone to take objects from shipwrecks. The convention provides a comprehensive legal framework for the preservation, protection, and management of underwater cultural heritage. And it also allows nations to exercise what's called sovereign prerogative over shipwrecks within their territorial waters. So this means if a shipwreck occurs within the territorial waters of a country, it could issue specific protection that would stop divers from looting objects from that wreck. So there's a lot of these, they get very complex. So what can we do as museum professionals to avoid violating these laws when we acquire objects? Because obviously no one person is going to know all of the laws and regulations. I've been talking about the major, most important ones, but there are many others as well. So my advice is, first, you need to know the laws before you acquire an object, an artifact, or a specimen. And this means you should take it your responsibility to know what is in your collection and the kind of things your museum is going to acquire, and develop an expertise in those areas. Insist that objects coming in have proper documentation. And this means copies of permits or licenses to collect, possess, import, and export objects, and all of those can be separate. You may have a license to excavate, but not a license to possess the objects that you dig up. You may have a license to export, but not a license to excavate objects. So you need to clarify that. You also want documentation for proof of ownership, proof of purchase, and all of those. The internet is a great way to look for information for laws and regulations of other countries. Many countries have their laws about cultural property available in English or in other languages. And if not, the internet also provides very useful translators that you can use to look at the laws. You should consult with your professional colleagues, particularly if objects or specimens come from outside your own country where you're not familiar with the laws, because it may be that people you know in other institutions have already dealt with problems and can help you. If you don't know anybody specifically, post your questions to some of the listservs that serve the museum community. Particularly Museum L is very useful. The new Museum Collections Care for Natural History, the NH Cole listserv, and there are other listservs as well. And this is a great way to get in touch with people who have dealt with problems. Most of the people that respond on the listservs are perfectly willing to help you. And it's nice to find someone who has already dealt with the problem who can help you navigate what you need to do to make sure those objects, specimens, or artifacts are legal. Another thing is to check with the websites of the agencies. And so I've listed those that you would use in the United States, but each country will have its own agencies, particularly U.S. Fish and Wildlife Service, the Bureau of Education and Cultural Affairs of the U.S. Department of State, the United States Immigration and Custom Enforcement's Cultural Property, Art, and Antiquities Investigations Site, the ICOM, the International Council of Museums, UNESCO's Fight Illicit Trafficking, Return and Restitution of Cultural Properties site, and then a couple of other places I like to look for information are Global Museum and the Art Newspaper, because they frequently publish articles about illegal activities taking place that can give you a heads up. And I have listed all of these URLs on the handout that Brad's provided. And I think Brad is going to put some of these into the chat as well, so you don't have to copy all of them down. Another thing that you can do is work only with reliable dealers and collectors. And this means people that have good reputations in the field. This is the mistake made by the people at the Museum of the Bible. They had internationally known curators that they had hired, but they worked with dealers that other people told them are suspect. They were warned by other people that are experts in the area, don't trust these particular dealers. And they went ahead and thought, well, if it's a dealer, everything must be fine. And of course it's not. So if you don't know the dealer yourself, ask other people and find out what that person's reputation is like. This all comes down to take the time to do a thorough provenance research on the object, the specimen, or the artifact that you want to import. And keep in mind that idea that you probably heard before, if a deal sounds too good to be true, it probably is too good to be true. So make sure, do all the checking that you can. So that is my advice on how to deal with this. I want to thank Brad and Museum Study for organizing and hosting this webinar. And I want to thank all of you for participating today and taking the time to listen. I know this is a very complex subject, so I appreciate your patience. And at this point, we can open it up for questions. Brad, if you, I presume you'll handle questions if there are any.
Yes, we did have one question while you were presenting, and that was someone from Canada wondered how much of the course would actually apply to them in Canada.
Well, again, because I am not an expert in all of these areas, we aren't going to deal with the laws of specific other countries other than the international laws, which affect all of us, but it will be an opportunity as we talk about these general ideas for participants from other countries to bring up the laws that they have. And this is one of the things I like about the course when we have people outside of the US, is it gives us a chance to compare and contrast laws in other countries. So as I said, I don't specifically have lists of laws in other countries, but I like for those to be brought up so we can discuss them. And you'll find that most of the laws are patterned pretty much on the US laws, and there will be some differences as to whether your system is civil law or common law and things like that. But that's how we handle it in the course. The principles that we're dealing with about ownership and provenance and making sure that you have clear title, all those are universal. So we deal with things at that level.
And as I mentioned in the chat, Canada does not have a version of NAGPRA at this point, but Canada has accepted UNDRIP, which I included the link in the resources and then again in the chat too, which is a UN regulation that they put in place regarding Indigenous peoples. And there is one article of that John identified as specifically relating to cultural property, which is the one that we highlighted in the resources.
Yeah, I believe it's Article 17, which talks about the fact that
12, I think it was. Yeah.
Indigenous people have the right to control their own heritage. And yeah, so this is a really good example. This is an international agreement. Canada is a signatory, the United States is not, but it is very similar to NAGPRA in that sense. I know Canada is supposed to be working on a law similar to NAGPRA that has been pushed by their native population. And I think you'll find that NAGPRA is going to be copied in a lot of other countries as well, because overall NAGPRA has worked very well. in terms of giving Native people control over their properties. Like all laws, there are problems with it, but I think it has done a lot more to bring about fairness and equity in the system.
Well, and as you mentioned, John, it has often taken the U.S. and other countries a long time to adopt the international laws, but not just adopt, but also enforce and put things in place to actually make them have some heft in a particular country. So an example, in Canada, they adopted UNDRIP a long time ago, but they have not really been implementing it within the cultural heritage sector. And that the Canadian Museum Association has been working for years on developing a better framework to help people do that, and has been rolling that out now in the last few months, and is getting much more aggressive about actually beginning to do it within cultural institutions. So it's a really important time.
And this is one of the problems is simply becoming a signatory to an international agreement doesn't mean your country will automatically then start enforcing it, because the country, whatever the country is, it becomes a signatory, has to pass enabling legislation within their own system of the laws that tells them how they will go about enforcing it. And it can get extremely complicated. But this is another area where we, as people working in museums, working with collections who are aware of the importance of cultural patrimony, can lobby our lawmakers. We can try to pressure them to help the U.S. become, or whatever country it is, become a signatory and enact the laws. We can look at example legislation from other countries and say we should have something like this in our country. We, as working together as a museum community, we can have a much stronger voice in that regard. And I think that is an important responsibility of collecting institutions to do that, to protect. Okay.
I have another question here, and then we'll go to Pat. Okay, so the question is, thank you for information about how to prevent acquisition of a legally murky object. But where do you start when you have inherited a collection that you think may need to be evaluated for potential legal issues?
You start by looking at your accession records, and you want to see how complete those are. The key thing that you'll want to look for initially is the date of acquisition, because if you have an object, in many cases, that was acquired before your country became a signatory to a law, or before a law went into effect, it is probably will be grandfathered in and you don't have to worry about it. That would not be true in the case of NAGPRA, for example, but it is a case of some objects, and you then want to go through the records, see exactly what kind of information you have, what information you might be able to gain. Are people still around who donated objects, or the collectors still around, former curators who could give you more information? And you have to build those files up, do the provenance research that should have been done originally, and try to get as much information as you can on those objects. And then when you find things that are problematic, you can start checking with colleagues to see if they would agree with you, get an outside opinion on it, and then you can then decide what you're going to do. Do you return things? Do you self-report? Do you keep these in your collection but merely take care of them and acknowledge that they were acquired under murky circumstances? The truth is, almost all museums have things in their collections they're not really sure about, that are probably a bit murky. That just happens over time, because these standards, legal standards, ethical standards have changed, and they evolve over time. And so we probably all have things like that. But the main thing is figure out what you've got and what documentation you have to support your claims.
Okay, let's go to Pat next, and then we have another question in the chat.
All right.
Thanks very much, John and Brad. So informative. I have a comment and a question. As a former museum registrar, making my first application for immunity from judicial seizure, I was advised that, and we all know now this is still the case, you should make your request very far in advance. This is not something that happens overnight, and hopefully you'll have your permit well in advance. The comment is that I was told that the permit must be have been granted before the object reaches US airspace, not even the, airport of import. So if you have something, flying from London to Chicago, it's once it hits the state of Maine, that the permit must be in place. So that's just something for everyone to keep in mind, because the department certainly is very backed up and short-staffed in making these, in granting these permits.
Well, thanks, Pat. I have never done that myself, and so that's really good to know that none of that is a surprise, having dealt with the federal government on many other issues. But that is really good to know, particularly about the airspace. That's not a surprise, but I was not aware that they would count airspace. But I had heard of things being destined for a certain city in the US and being seized at the port of entry. But that's probably where the airspace rule comes. So that's really good to know. Thanks.
And something that is just always a hint as well, that if you're shipping in or out materials that are CITES or immunity, you might want to crate them separately from other objects that are not of those materials, so that if one object is held or seized, your entire shipment doesn't get seized.
I have had experience with that. And yes, you are exactly right. And you want to really go the extra mile there, have copies of your CITES permits with the objects or the specimens, and packing them separately is a good idea, because otherwise an entire shipment can get held up. So yeah, those are all really good pieces of advice.
And my quick question is about the Lacey Act. I think you said, John, that one of your examples you showed was a Damien Hirst object that you said included a human skull. And I'm wondering, why is that? How is the human skull? How does that fit into the Lacey Act?
It's actually the bones. It's bones in a human skull, and the bones are not human. So the bones are covered.
Okay. Because I was going to say humans aren't endangered yet, at least. So
not yet.
I wondered about that. Okay, great. Thanks.
Thanks for your input, Pat. Did have another question. In the case of natural history specimens illegally collected in the original country, also applies the repatriation to original country?
Meaning the specimens would have to be repatriated? Is that?
Sylvia, do you want to jump in here? There you go.
Well, I work in the natural history department in Costa Rica in the National Museum. And my question is, if people that collect here in Costa Rica specimens illegally and then take them to museum or collection in another parts of on other countries, if there is also possibility to repatriate them or
in terms of United States law.
In
terms of United States law, there would be, because if it was discovered that those specimens had been brought in illegally, they would be seized by U.S. Fish and Wildlife, who is responsible for enforcing it, and U.S. Fish and Wildlife would then make the decision on what to do. And I have dealt with them on some issues like this. Often things are repatriated, but not always. Countries don't always want them back, or there isn't always a place to send them back. But you, from your end of it, if you were aware of this, Costa Rica could make the request to U.S. Fish and Wildlife to have specimens repatriated. And the way this would act in other countries would probably come under CITES, and that would be a little more complicated. I think this is going to be one of those cases where the laws in each country will be a little different. But if it was, if it fell under the Lacey Act within the United States, yes, that potentially could result in repatriation, and it would probably be best, if you're aware of it, to make that request to Fish and Wildlife that they come back to you.
Thank you.
Do we have any other questions? I'm not seeing any comment at this time. I'm going to place the link to John's course on laws and collecting. Oh, we do have another question. I placed the link to John's course which will run in August this year, actually begins on July 31st because of the timing of the week. We always like to start our courses on a Monday, and they almost all run for 4 weeks long. So the other question we have is, what would be the first steps with ivory in collection?
Okay, again, your first step is going to be to look at the date of acquisition. And because the laws on ivory are fairly specific when those took effect, so the object itself may legally be in your collection. The problem is going to come if you want to send that ivory object to some other place to be exhibited. And particularly if it falls under CITES, both you and the other institution would have to have permits. And if you wanted to ship it internationally, that would probably not be possible under the way the United States is currently interpreting the laws on ivory. This is one of those cases where I would advise, if you have an ivory object in your collection, is to first off, do your background provenance research, get all the information you can. If you think that object is illegal and you want to see what needs to be done with it, you could then contact your regional U.S. Fish and Wildlife office and ask them what to do. U.S. Fish and Wildlife overall has been extremely good about working with museums if they self-report. If they say, oops, we have this illegal object, we did not intend to have it, here is our situation. And they have been very good. Often what they do is they let you keep the object and they work out an arrangement. Sometimes they take it and transfer it elsewhere. But I would check with them. There are 7 regions, I guess, in the United States. You can look at the U.S. Fish and Wildlife map and contact your nearest regional office for law enforcement and ask. But you need to get that background information first. You'll want to know where the object came from, if that's possible, and certainly the date that you received it. Right in the past, antique ivory was fairly easy to send from one museum to another, but the way the ivory laws are being interpreted now, even antique ivory cannot be loaned out without all kinds of permits, and it certainly cannot be imported any longer.
And Margaret points out that you want to make sure that it is actually ivory, because there were a lot of early plastics made to as a substitute to look like ivory.
Yeah, and then the kind of ivory can be an issue too, whether it's elephant ivory or from walrus tusk or teeth of some other animal. There are experts that can help you identify the ivory, but ivory gets really complicated because there is a massive worldwide trade in ivory, and the elephant ivory is particularly damaging to wild populations. There is a lot more information on ivory available if you just Google looking at protections on ivory. The identification usually takes an expert, and what they can usually do is look under a microscope and look at the structure of the ivory and make an identification that way. Yeah,
ivory is a great example of a larger problem in the world of transporting animal parts illegally. It's probably the most well known, but there's a lot of other.
Yeah, and someone has pointed out that false ivory is often cellulose nitrate, particularly historically, and that's complicated in itself because it's very flammable. And another person has pointed out that they're helping their art museum with elephant and rhino tooth carvings, and they're communicating with U.S. Fish and Wildlife, but they're still working out there. These things are never easy to resolve, but you do want to try to clarify them as much as possible. The longer the time passes between when that object entered your collection and when you start looking for information, the more difficult it will be to find what you need, the information that you need.
Great questions, and thank you for the input from people who are actually dealing with these things, because that's very useful. And that's the kind of thing that we are able to experience in the course as well, is everyone has different experiences that they can share. And that's really a valuable component of the course, is that we do have an opportunity to share those experiences with each other. And it's always more fun when we have people from other countries and can learn about each other's situations and experiences.
Yeah, definitely.
So, well, if no one else has any questions, I want to thank you all for joining us today. It's been a really fun interaction with you all. And I've dropped links. If you have any questions about museum study, you can reach me at my email address. If you have questions about collection property law, you can reach John at his email address, which I also dropped in there. I also dropped links to Museum Studies Facebook and LinkedIn. If you want to follow us, you can keep up on future webinars. We also have a blog. There's a blog email list if you want to join that, but I also promote the blog on our social media so you can hear about new blog posts that way. And then also we promote our courses on our social media. So it's a way to find out when the next courses are. So with all of that, thank you all for coming. I will be sending out a link to the recording when I get that up on our YouTube channel to all of you. And I will also update the resource list that John had put out, because as we discovered, thank you to whoever it was who figured that out, that the link to the Lacey Act was out of date, and Benjamin provided the new updated link. So I will update that link in the resource list and send that out when I send out the link.
Sorry about that. I had tried all those links myself to make sure they were working. So thank you, Benjamin, for catching that.
In just a couple of days, the link went back. Go figure. And this is one of the challenges in our courses all the time. We constantly have to be checking those links because they change all the time. And also a note to you, if that link is to a document like a PDF, grab the PDF, because then you'll have it even if the link changes. So again, thank you all for coming.
All right. Thank you, everybody.